Wait. It's 11 o'clock. Who's supposed to start this stream? My God. I don't know I don't know who's responsible for any of this. They need to get on it. I just need everyone to know, it's Brecken's fault. It is Brecken's fault. All right, check. Check 1, 2, 3. I just need reassurance from the world that I can be heard. Good morning, ladies and gentlemen. Good morning. It's Saturday. We have court to watch. I hope everybody's ready, because we have some good ones in store. It's been a long week. It's been a good week. Been collecting. Hope you're ready. About that time. Ladies and gentlemen, I am your lone wolf Oozle. It is a Saturday morning for me in my time zone. It's 11 a.m. Central Standard Time. It's noon Eastern, and it's time for some court. For those of us who have not been able to hang out and watch court all week long, this is our chance to get caught up on some of the biggest court cases of the week and we're here to chat about them together. Ladies and gentlemen, we're starting our morning off with a nameless judge from Thurston County with a guy who's just not happy about things. Then we're moving to Judge Hammond, who's going to deal with a Pro Se Sov Cit. And we got Judge Simpson doing the things that Judge Simpson does oh so well with Mr. Allen, and Judge Middleton is always a little disappointed about something. But ladies and gentlemen, all of that starts right now.
So are you in the back there? Come on up. Good afternoon. And what's your name?
Matthew Parsons. Well, I may be on their 3 o'clock docket.
Right. Oh, you're here. Matthew Parsons there. Failure to renew expired tabs, operating car without insurance. Looks like you got some.
I have visuals here.
Okay, thank you much. Oh, these are copies of the. Oh, okay.
For the court.
All right, thank you.
All right.
Let me just bring up your. You are here. Okay, you are here for mitigation.
Your Honor, the nuances between the litigation and contesting are a little beyond me. The situation, a little difficult, has stirred up some other problems for me. And so what I'd like to address today, beyond showing compliance to the court that the car is registered and insured, is I'm a retired cab driver. I was a professional driver for many, many years. And I worked 6:30 in the evening till 6:30 in the morning in a 24-hour town. So every aspect of my function in the wheel is safety. And in my job, I was 33 times more likely to be murdered at work than a cop. Very dangerous. So when this officer, there was a white SUV behind me, following a little close at 60 miles an hour, and then he surged forward. And I instinctively hit my signal and moved to the shoulder. And then he threw his lights on. And when I asked him why he thought it was acceptable to put me in danger like that, his response was that he had to. And I told him that if he's violating the law, isn't he required to identify himself with lights and sirens? Isn't he subject to RCW 46.61.145 following too closely, just like the rest of us? And he didn't care for that and went on a fishing expedition because I had a cigarette sitting on my passenger seat and I hand roll my cigarettes. So you can imagine what he tried to misconstrue that to gain leverage. And I just wasn't amenable to the fishing expedition. And furthermore, he came back with patternized harassment that I've faced for the last 40 years here in Washington, where police run people's ID and they don't check birth dates and they don't check middle initials, and they saddle people with warrants that are not applicable to the people.
And sir, I am listening. I'm reading through the documents you're providing here at the same time to make sure I'm listening and showing. And I see your DOL registration on July 6th, which is the incident date as well. And it looks like, according to the officer's affidavit, says the comments he made to him were, "I just paid to have the tab due." And then the comment as well, the driver did not have insurance at the time of the stop. Given me are your ID cards with the vehicle that was involved in this. Insurance through Progressive, looks like, effective April 15th of 2025.
Yes.
And so is what you're telling me that you paid for the registration, the DOL registration on the same day prior to the interaction with law enforcement?
I do not own the car, and I do not have the means to keep up with all the paperwork all the time. And I need some help with that. And I can't carry a backpack, and I can't survive outdoors anymore. And I've been in the car for several years. And they've never stopped to ask me if I'm okay. So him endangering my safety and flying up on the back of my vehicle like that, I don't think he had probable cause to continue the stop. I think he gathered his evidence illegally, and the blue smoke that I got trying to address it through supervisors made me very.
Well, if I can get back to the question of when did you pay for the DOL registration for the car? Because what you handed me shows issue date July 6th.
Okay.
Is that
those papers were given to me like 3 weeks later by the owner of the vehicle?
Okay.
So I believe that I handed if I may offer to the court. While I was stopped, I texted the car owner. Mm-hmm. He had it done within minutes.
Okay.
Within minutes.
All right. So I gotcha. So here's what I'm going to do. So it looks like, based on what you're showing me, and I guess for the record here, so we're here for 2 violations. One is failure to renew expired tabs. Violation 2 is operating without insurance. For violation 1, what we can do is, even though you have given me proof that day of the incident, the registered owner registered the car, renewed the tabs with DOL, and you got proof of that. What the court is able to do is that it's going to be found committed, but we're able to reduce that because even though it's a quick period after the interaction with the law enforcement, if it wasn't registered at the time, that's still a violation, even if it was registered thereafter. So that can be reduced down from 237 to 200. And then operating a vehicle without insurance, that original ticket is $559. However, you provided proof that you were insured at the time. And so what we are able to do there is dismiss that infraction. So find the proof, no proof of insurance, but had it at the time. You provided proof that you had it at the time. So we'll dismiss that violation. There is still a $25 administrative fee, just that reflects the fact that it was filed because there wasn't proof at the time. And you still have that on you. But the infraction itself is down now. So total would be $225.
So,
one second. I'm sorry, I misspoke. The DOL registration is, we can reduce it further, 200 down to 175. So it's going to be a total of 195.
Yeah, I don't have that.
Well, you are able to work with the clerk to set up a partial payment.
Right.
Plan.
So how do I contest the ticket? How do I address his unlawful actions where he violated the law to gather the evidence for the stop?
So I think you're talking about bringing some sort of civil lawsuit against the police
No, I'm
department.
talking about contesting the ticket because he didn't have probable cause for the stop.
Well, so probable cause for that's not the right standard. It's and this is not a criminal matter. So you're talking about probable cause is relevant in.
So he can break the law to gather
No,
evidence.
you can't. The evidence that you're talking about here is not being used against you. This isn't, again, it's not a criminal matter. This was a traffic stop and
A bad stop.
Well-
Where he endangered my life, where he ran me off the road to get close enough to read the plate, and then said he had to, that he had to violate the statute to gather the evidence for the stop. It was a bad stop. I'm out there dying. I'm making end of life preparations. I've been on the streets for decades. They've never stopped to ask me if I'm okay once. And then they cause me this type of anxiety and panic, impacting my health negatively, smoke screening me when I try to go through channels to address it. And I'm here for relief from the court. And I'm not finding that.
well, I'm just
I don't have concessions to make here.
Sir, the court's making its ruling. All right, we're dismissing the driving without insurance, which is a vast majority of the ticket here, and that's going away as dismissed. And the driving without a registered certificate with DOL, given that it was registered soon after the interaction, that's also being reduced down to $175, which is as far as the court can go. But on the traffic citation, it's being found committed. And so the total is going to be $195. You can work with the clerk to set up a partial payment plan. There are resources at Thurston County Resource Hub to assist with social services, but that's going to be the court's ruling. You're free to go, sir. Okay. So are you there in the middle?
I'm Benjamin Mabry.
Leave your 5C there. You are here for a mitigation hearing on this meeting.
Right.
All right. And go ahead. What do you have?
I have tinnitus, so I couldn't quite.
Oh, I'm sorry. Let the court know what do you have to say.
Well, I was speeding. I was a little late for school, and I work at Timberline High School as a paraeducator. And I'm 72 years old on Social Security. Don't make a whole lot of money. My wife passed away August 30th last year ago. And I'm paying the entire rent. And just wondering if I can get a reduced fine.
Yeah, we can certainly do that. And I'm looking at it's like 15 mile per hour over speeding ticket here. And giving your comments here. Anything else here? Also, we'll go to. So we'll take that ticket down to $93.
I'm sorry.
That's right.
93.
Infraction is found committed. Speeding ticket is found committed, but we'll reduce the fine to $93. Obviously, about as low as we go on something like this. So that's going to go from 176 down to 90.
Okay.
And you can take this paperwork here, and you can pay it all at once, or set up a payment plan with the clerk right out here.
Okay. Thank you.
Thank you, sir.
All right, Mr. Sigsby, you're up. 25T01947FY, People of the State of Michigan versus Robert Wayne Sigsby. And Attorney McGrackis, you'd like to place your appearance on the record?
Kimball Gracchus on behalf of the people.
And Mr. Sigsby, can you state your name, please?
My name is Robert Sigsby.
Okay. All right, we are here today on this matter. We're back on an adjourned PCC. We've had a couple of PCCs at this point. The reason for the adjournment today was to ensure we were going to check on the exchanging of discovery. We were here on August 14th, and Mr. Sigsby has stated that he still needed some discovery. He wanted body cameras of all police officers present at the time of his arrest. and I did order any available body cameras to be turned over to Mr. Sigsby. So we have a probable cause conference on September 11th as well, because I wanted to give Mr. Sigsby an opportunity to, file any valid motions that he may want to file prior to exam after receiving all of his discovery. But we set today to make sure that there weren't any issues in regards to discovery. So having said that, Attorney Bagrakis, what information do you have for me?
Well, I know my recollection was that Mr. Initially all the body cam videos were sent to Mr. Hilliker, and I believe he provided them. He indicated that he had provided them to Mr. Sigsby via a thumb drive. My recollection was also I see we have some cruiser cams, which I had directed my paralegal to send to Mr. Sigsby because, of course, as the court remembers, Mr. Hilliker was removed from representation. So now we have to deal with directly to Mr. Sigsby. And there are, to my knowledge, I don't see nor have any other body cams that are available. We've given or will be able to provide him what we already have.
Well, part of the issue, Attorney Bagrakis, was that why I set today's hearing was last time we were here, I believe Attorney Young was here for the prosecutor's office, and there was some, I don't know what I would call it, back and forth maybe about how discovery was going to be exchanged and where Mr. Sigsby could pick that up. And so I wanted to make sure that any outstanding discovery was handed to him today in court so that we wouldn't have any questions about where discovery is, whether or not it was exchanged. So
okay. Now that I am looking at Mr. Young's note to that effect, and obviously that being in court, we can't provide it to him via hand delivery. So
well, and this is the problem we run into when I don't have an assigned prosecutor. Because that information probably wasn't relayed to you for today.
Well, with all due respect, we've tried to provide as best coverage as we can given the circumstances, but
so what's your plan to get that to Mr. Sigsby? I guess
what do you want? I mean, are you asking us or ordering us to give it to him directly?
That was my order last time in court. I ordered it last time in court. Yes.
Okay, but obviously, if it was today's date to give it to him in court, we all knew that we weren't going to be in court today, even if I had it in my hands. Right?
Well, no, actually, no, though. Wait, because last time Attorney Young was here in person, we were all in person. And so we had this kind of long conversation about how a discovery was going to be exchanged. And I said, you know what? I'm going to order any outstanding discovery be provided to Mr. Sigsby, and I'm going to order that it be handed to him in court on August 28th, 2025 at 11 o'clock a.m. That was my order. And I did that in the hopes that it would ease the process a bit, but it hasn't. So hold on just a second, Attorney McGrath, because Mr. Sigsby, what did you want to say?
I understand what the court said, but then you were requiring us to come out to court to hand over some this discovery.
Yes.
All right. Well,
that was my order. I mean, that's what I'm saying. That was my order.
That's fine.
Hold on just a second. Hold on. I need to let Mr. Sigsby speak. So hold on just a second. Mr. Sigsby, go ahead.
It's critical, because of the angle that the police officer, I watched him pull the sack out of my pocket, my personal Native American herb, and then he shoved it back in and took me to jail with it. I watched this. My friend watched it. He got video of it. I'd like to see the other 10 cops that came there with their guns out.
But the issue is just getting.
I could meet you. I want to confer with the prosecutor. I got a right to do that. So I was wanting to meet.
I'm not. There's nothing really to confer about, sir. I would recommend
Michigan State Constitution.
I would recommend against that, and I will judge. I will do what I can if the court will indulge us another adjournment. I will make sure that I at least look into the other, making sure that we have whatever copies of either cruiser cam or body cam we have available, that we will get it copied. And if the court tells me to show up at a certain place and time, I will be there, or I will have a representative there to hand deliver it to Mr. Sigsby.
So, Mr. Sigsby, if the remaining videos were put on a flash drive, you can use that.
I can use that.
Okay. So here's what I'm going to order today, and I made an order last time and it wasn't followed, but Attorney Bagrakis, I know that you, hold on. I know that you will ensure that my order is followed. And I know sometimes it's hard for the younger attorneys, the newer attorneys to relay that information for whatever reason, but it was an order that I made. I thought I was very clear about it. But I know that if I tell you, I know that it will get done. So I'm glad that you're here today. So what I'm going to order today is that the prosecutor's office is to put any outstanding discovery on a flash drive and have that available for Mr. Sigsby to pick up. And where would he go if he were to come to the prosecutor's office to pick that up? Where would he go?
Well, he could come to our office and make contact down here at district court and make contact with my people, and they will let me know that he is here, and we'll make sure that it gets delivered to him, unless you want him to appear in court sometime when we're down there. And
what I'm going to say is I'm going to pick a day and a time that he can be there, and that way someone from the prosecutor's office can just walk out with flash drive and hand it to him, and that's that. I don't want to have to set another PCC. We already have this September 11th date. So what I'm going to say is that let's see, Mr. Sigsby, if we said Wednesday the 3rd at some time, will you be able to be at district court to pick that up?
I do believe at this time I can.
Judge, can you again? I apologize. With the holiday and everything, can we do it the following week or later in the week? I mean,
we can do later that week. So we'll do Friday the 5th. Okay, so Friday the 5th. Are you available on that day, Mr. Sigsby?
I will.
All right. So Friday, September 5th, 2025 at Mr. Sigsby, you give me a time.
No, I like 11.
11. At 11 o'clock a.m., Mr. Sigsby will be at the district court at the prosecutor's office to pick up the flash drive, which will have any outstanding discovery on it. It sounded like maybe there are a couple of dash cams. We already had this conversation as well. I know, Mr. Sigsby, you say that there are, I'm not saying I disbelieve you, I'm just saying what you say is that there should be multiple body cams. Prosecutor's office has what they have. If you believe they have insufficient evidence, then that's something that you bring up at trial. But we're going to go ahead with the preliminary exam with what they say they have. And you can address that you think that there's some things missing or not, but we're not going to be able to not move forward because of that issue. Okay. So Go ahead. What did you want to say?
It's kind of crunching my time to watch the videos. I mean, I'm going to do it.
Yeah.
So there was like 3 jurisdictions there, plus the sergeant was there. So he was close. You would think the sergeant of the sheriff's department would have his body camera on. And then there's at least 2 Burton cars. I do believe there was around 4 Burton police there. And I mean, if they're running out here, it looked like I robbed a bank is what it looked like. And there's that many people with their police, with their guns. And I couldn't understand this over a traffic stop, a civil infraction. That seatbelt is not an arrestable offense. He had no reason to ask me my ID. So Colder versus Law says I don't have to produce an ID.
All right, we're not getting into those
Okay,
things. But I do want you to relay that information of the people that you thought were there, so that Attorney McGregor.
Yes, and the Flint Township was there also.
Okay. All right.
So
Good.
one of these people should have the angle of the police taking it out and putting it back in my pocket. That's suspicious of a crime in my mind for any cop to lay you out like that. It's that big of a bag. How could you not find it in the pat down?
Okay, and so last thing is the probable cause conference that we set to actually move the case forward was for September 11th, 2025, 11 o'clock a.m. We can leave it on that date, or we can put it a week after that on the 18th if you think you'll need more time, Mr. Sixby. It does not.
Time is precious. I'd like to have more time. It would be nice for me.
Okay. Attorney McGregor, are you opposed to putting the next PCC on September 18th?
I am not opposed to that.
All right, good. Okay, so then we will.
Judge, may I inquire just one thing? Did Mr. Hilliker, did Mr. Sigsby receive from Mr. Hilliker the discovery that we already sent to him?
Yes, right?
Yes.
Yes.
And there was a flaw in it. And I remember
Well, I don't know. I'm not getting into a discussion about what there is or isn't. What I want to know is, did you receive it from Mr. Hilliker so we don't have to duplicate efforts?
Right. We don't need to duplicate the arresting officer's body cam because it's worthless the way he leaned on me that day.
Okay.
Well,
we don't need that right now, but you do have, I remember we talked about that. You do have that discovery.
Yes, I do. For all
Okay.
parties.
Okay, so one more time. This is what my notes state. This is what we're doing. We're going to put any outstanding discovery on a flash drive, and that will be available for pickup by Mr. Sigsby at District Court on September 5th, Friday, September 5th, 2025 at 11 o'clock a.m. That is an order of the court that needs to be done. Probable cause conference will be moved to, and I will find good cause for that because of these discovery issues. Probable cause conference will be moved to September 18th, 2025, 11 o'clock a.m.
all right. Thank you.
I never.
All right, thank you. All right, and then that's all of our PCCs today. I believe Attorney McGregor, do you agree?
Yes, I believe we've taken care of all of them, Judge.
All right, very good. Then have a good day.
Have a great weekend.
Yes, you too.
All right.
We can write you out a notice if you want one.
Yeah, something on paper because I got enough things going on in my own life. You know how that goes.
I understand. All right, very good. We'll see you on the 18th.
Get this from her right now.
Get it from clerk's office.
Clerk's office.
Yep.
In a few minutes. Thank you.
All right, you're welcome.
Oh, yeah. No. Another one that,
Court does call the cases of the people versus James Daniel.
Assistant Public
Trevor Mabel for the people here.
Assistant Public Defender Alexis Dipswith on behalf Mr. Daniel for case ending in 1320.
And Sherilyn Foster Tucker on behalf of James Daniel in the other case.
All right. What are we doing?
Your Honor, I may have preemptively submitted a green sheet, but after having further discussion with sister counsel, I believe we're going to set both matters for exam just to keep them together.
Discovery is complete on both matters.
To my knowledge, yes.
To my knowledge.
People, other witnesses available tonight.
Yes, sir.
Preliminary examination in person will be set September 9th, 2025, 9 a.m. That is before me in both matters. Esteban, I have a community corrections violation. Are counsel aware of that?
Yes, Your Honor.
Yes, Your
Would you
Honor.
like to address it? Because I issued a warrant. He's got a bond of 50,000 cash surety that's not been posted.
Your Honor, we would ask that his bond be reinstated. It's my understanding that his community corrections issue wasn't an attempt to evade drug testing. So he did initially go there, had that one drug test. The gentleman he spoke with said, "I'll see you next week." That's why he came exactly a week later to do his drug testing again. And that's when he realized he had gotten that different appointment from, I believe, a different individual he was speaking with at community correction. He did keep attempting to show up, albeit maybe not on the exact dates that he was supposed to. So it was never really an attempt to avoid the drug testing. Your Honor, he's more than willing to go test now. He indicated to both me and sister counsel that he would test clean if that was the case, except for possibly some
He doesn't
THC.
come in when he's supposed to test.
Your Honor, it's my understanding that it's,
Sometimes he just shows up or just doesn't report.
and I think the other issue, Your Honor, so he does work full time. He is working at a group home. Sometimes he's there at all hours of the day. So I think that has gotten in the way. He also does live in Wayne, Michigan. So sometimes it has become difficult for him to get transportation to here. But again, it was never a attempt to try to avoid drug testing. These are older cases, Your Honor.
He did.
He's willing to go test today and get everything set up today so we don't have any future issues, Your Honor.
Not like they did anything the first time to him. He just kept doing whatever he wanted to do. Anything else?
I think Ms. Serves covered everything, but we would just ask that he be given another opportunity to enroll in testing and to show that he can be in compliance.
And Your Honor, if that was the case, we'd also ask that he be allowed to test closer to home because I think that was the main issue. Like I said, these are some older cases. He's been in treatment since these cases have occurred. So again, he would test clean if he were tested today.
Hasn't tested.
He tested the initial time, Your Honor, on August 1st, I believe.
I know. And then hasn't tested since.
Excuse me, Your Honor. Can I speak?
Go for it.
Yeah, I showed up. Yeah. When I tested, the guy told me he'll see me next week. When I showed up, the lady said I was supposed to be there the day before.
Correct.
And she said, okay, well, come back Monday. Monday I was at work, and I got slammed at work. I couldn't leave. I had to wait on my relief because I work at the group home. So I wasn't able to leave. I called. They said if I ain't there by 6 o'clock or something, then come tomorrow. I showed up the next day. The lady said there was a warrant out. When I signed in at the desk, it was like, it's true. She put a warrant out already. So I contacted my attorney.
Because you haven't tested.
I showed up 2 tests. Every time, if she'd have let me test the Friday when I came, when she was saying I should have been there that Wednesday, but I was never told that I had to be there on a specific date. I just was told a week, next week.
Well, reduce the amount that's on the warrant. The warrants are 50,000 cash surety. I'll reduce it to 25,000 cash surety, but defendant is your man. Courthouse case, People versus Justin Duffney.
What on behalf?
Your name, sir?
Justin Anthony.
I have before me a plea form that indicates that the defendant, what word is that? Who wrote this?
I did, Your Honor.
Okay.
Your Honor,
Is that supposed to be methamphetamine?
no, actually, Your Honor, I don't normally do caffeine in order to stay awake. Coming down here, I had a Mountain Dew and I have hand tremors because of
Yeah, no, that's okay. I just can't. I'm trying to figure out what it is.
It was a possession of methamphetamine. It's going to be pled down.
Is it the use of methamphetamine?
Yes.
Okay, that's the word I couldn't repeat. All right, that's the 1 year offense. Upon successful plea to that charge, then count one would be dismissed. And the sentencing judge waiver is checked. However, this is my case. If he pleads,
I thought it was, but I just wanted to make sure.
gotcha. All right, that's the court's full understanding of the. May I have him sworn?
Raise your right hand. Do you solemnly swear in the permanent testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Justin Duff.
All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court. Understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights? You'll see a copy on the podium, probably under Mr. White's. I need to look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading, you'll be giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of November 5th, 2024, at the location of Bemis Road, Pittsfield Township, Washington County, State of Michigan, did you have methamphetamine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was methamphetamine?
Yes, sir.
Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would no longer be bound by any recommendation or sentence evaluation, and you could not withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be September 10th, 2025, 9 a.m. before me.
Thank you.
And will continue.
Your Honor, can I address the bond issue?
Certainly.
In this particular case, Mr. Duffney was arrested. Charges were brought. He came in initially, was told to test for drugs, and when he didn't initially do that, when he finally did, he was positive for some controlled substances. He's been in jail for some time. I would consider possession of a controlled substance, in this case, a dangerous one, but a controlled substance is basically a victimless crime. The only crime would be Mr. Duffney. He's now facing 1 year in the county jail maximum as opposed to a 10-year sentence that he had as a possibility before then. I think under the circumstances that it should be fairly easy to guarantee he'll reappear and that he'll appear for testing. Again, I personally have been to the house. I know where he lives, and I know where he works. And I think that probably it's unlikely that he would need any more jail credit before he gets sentenced. So I would just ask the court.
Has he gotten himself involved in any treatment at this point?
He had a problem previously with narcotics, and he was on a Suboxone program at the time that he was picked up. If you look at what he tested positive for, not that I'm suggesting that we switch our addictions, but I don't believe he's tested positive for narcotics.
Oh yeah, he was. Yes, he was. He on July 31st, his test was positive for amphetamine.
Correct. and cocaine,
And cocaine. Those are the large ones.
but not narcotics. The Suboxone was working. And again, as I said, he's got a 1-year maximum. He's going to get out of jail fairly soon, no matter what you do.
But
There's no reason to hold him now.
treatment. Well, then we'll have to just see what I'll do. I don't need a response from people. Motion for bond reduction is denied.
I didn't hear you, Your Honor.
Motion for bond reduction is denied. Bond will be. Court calls case People versus Brandon Fleming.
Sorry to interrupt. Jake Kill on behalf of Mr. Fleming. Judge, can we set this matter for exam? What I'm going to ask, Your Honor, is I noticed you've been setting them for the 9th. I have a probate trial that day. Can we do it the following?
Trying to pick your date.
No, I'm not trying to pick the date. We could make it. No, I'm not. I'm just asking if we can go the following week, if possible.
There be any objection from the people? Discovery is complete, Mr. Killowald?
Yes, Your Honor.
Discovery being complete. Is he held on anything else?
No, Judge. He has no other charges. I was going to make.
Well, then I've got a problem. I'll be honest with you. I got a problem then putting it out 1 week. We've got a ton of people in custody. I have 65 today. And
If you want to make it next week, that's fine with me.
no, it would be the 9th. I mean, my problem is, Mr. Killowald,
I'm sorry.
it's putting it out an additional week. He's going to remain in custody, and it may be that he doesn't have to remain in custody.
Can I address bond first? Just very briefly.
And then I can set it for the 9th and tell you to work it out. But you can go ahead and address bond.
Judge, he's 32 years old now. The only prior criminal history he had when he was 19, he had a felony. He's working. He promises to stay away from the victim. And again, I'm not trying to denigrate the victim, but she also has been charged with assaulting him. It's a toxic relationship. He understands that now. He will stay away from her. If the court would grant a bond, even if it's Tether bond, he will appear for court so we can address this issue.
In this case, we originally requested $50,000 cash surety, so I think $20,000 cash surety to get, honestly, based on these facts. The victim and defendant were dating. She was 7 weeks pregnant with their child. A friend reported hearing ongoing abuse by the defendant against the victim that included loud noises, screaming, banging. She overheard the defendant telling the victim that he was going to kill her if the baby. She called the police. And during this incident, he was accusing her of cheating on him. He then pushes her to the ground. She gets up, tries to call her father, and then grabs her. There's takes her onto the bed and sits her arms down. He then uses his body weight to push her face into the bed, impeding her breathing, all while she's telling him she cannot breathe. I have concerns given that in his criminal history, he has a conviction from 2015 for 2 domestic violence charges as well as assault with intent to commit sexual penetration. And after this incident occurs, he then calls 911 pretending to be the victim, saying that she's suicidal and that she has a knife. When it really was not her fault and trying to discredit her to get ahead for about this incident. So I have concerns on that as well. And based on all that Your Honor has about me has said.
I have nothing further, Judge.
Well, I'll set it for the 16th. I'm not really happy about it. I mean, I think counsel has to make sure.
Judge, I could be here on the afternoon on the 9th. If we could set it for a later time, I'll go with the 9th.
Well, I'll set it at 9. You'll have to, whose case? Is it mine? I'll just take it. And you have to let my staff know on that date that you're going to be late. And then we'll do that. But I am loath to have him sit in jail for another week.
That's fine, Judge. I appreciate your consideration. Thank you.
Court does call the case People versus Sean Dorsey.
Fellas for people.
Oh, Zerbs, don't nod at her like that. Right? No, she didn't do anything. No.
Laura Yagi, public defender with and on behalf of Mr. Dorsey. Mr. Dorsey, could you state your name for the court?
Sean Dorsey. Thank you. I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of assault and or assault and battery to 93-day offense. Upon his plea to that charge, count 1 would be dismissed. There is also the boxes checked, but there's no delay deferred for A. However, a defendant is able to enter the treatment court for a term of his probation. People will agree to prosecutors for exemption.
That's correct, Your Honor. I also make a record at this time that the people would also like to see a mental health referral and follow all those sorts of treatment recommendations as part of this defendant's probation, but that is not an element of our agreement. It's our advisor.
Is that a correct statement, Ms. Young?
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony about the whole truth and nothing but God? State your name.
Sean Dorsey.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of assault and or assault and battery. That's a misdemeanor. It is punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your, well, do you understand what a no contest plea is, sir?
Yes, Your Honor.
All right. 2 things I have to make sure that you understand is that, first of all, it means that you're not further desirous or wanting to contest this charge. You understand that? The second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand that although I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Basis for the no contest plea.
Lack of memory, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form?
Yeah.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what was stated here today on the record to get you to plead no contest?
I'm sorry. I don't understand what's happening, but sure. Yeah.
You don't understand what's happening?
Am I going to treatment? I've been told twice I'm going to treatment.
Okay. So hold on a second. Do you understand that right now you're entering a plea to this charge?
Yeah. The no contest to misdemeanor.
Okay.
That's what we're talking about.
Yeah, that's what I'm talking about right this second. But you're indicating you're not sure what. I guess I'm on.
I just didn't hear but the last thing you said. That's what I was confused about. The last thing that you mentioned.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, I don't. Yeah. I'm just. Am I doing my? What is this? Are you guys trying to have me do drug court or treatment?
So
that's what I'm confused.
Right. As part, here's what the court understands. All right. That you're going to enter a plea. They really haven't made the treatment court part of the agreement in this case, although it is noted on the plea form that if you can get yourself into a treatment court, they agree to a prosecutor's deferred. Okay. But the agreement is not contingent upon you getting into the treatment court. That makes sense to you?
Yeah.
Okay. Does that answer your questions? And sir,
I think so.
Okay. Well, hold on. You're in the middle of this plea. So if you want me to pass it so you can talk to Ms. Yagi some more so that you're absolutely clear about what you're doing, I don't have a problem doing that. Okay. I have to make sure you understand what you're doing and that you're clear on everything.
Yeah, she's explained a lot to me. I'm very clear for sure on that.
Okay. So you don't want more time to talk to her about this?
No, I think you just explained it too. I understand now. So thank you. I appreciate it.
So whose explanation was better, mine or Yagi? No, don't answer. Don't answer. All right. So So, sir, has anybody promised you anything other than what we stated here today?
No.
Has anybody threatened you or coerced you in any way?
No, sir.
All right. You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yep. Yes, sir.
Okay. The court had been provided and has reviewed Washington County Sheriff's Office report for their case number 2549864. Counsel, there's no objection to court reviewing their report. Is that correct?
No, Your Honor.
All right. Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to apprise you that if between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, that the Judge Washington in this case would no longer be bound by any sentence evaluation and or recommendation. You understand that, sir?
Yes, sir.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which would cause this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 25th at 10 a.m. Judge Washington.
September 25th, 2025, 10 a.m. before Judge Washington.
Your Honor, may I address bond?
Briefly.
Okay. First of all, I do actually, I talked about this with Ms. Feltz. I do have a stipulation and proposed order for release to treatment that I would ask the court to sign. He's very eager to get into treatment. I was going to ask for a PR with the understanding that Mr. Dorsey is seeking treatment himself. Even without the court order, even if the court was to release him today on a PR, he would still go to treatment because he knows that's what he needs and that is what he wants. And we've had a lot of genuine conversations about that. So I would ask the court to consider he has no criminal history, no other holds, no probation, parole. He's been in 36 days. Obviously his sentencing is not for another month. So I would ask if the court would consider a PR with testing, very strict testing requirements, and even a bond condition that requires him to submit proof that he's going to treatment and meetings. One of the things he said to me that really stuck out to me is he's used to going to multiple meetings per week, like at least 4 a week. In the jail, he's only able to go to 1 a week. And he said that's not enough for him. And that's one of the main reasons he's eager to prove his commitment to recovery is by going to more frequent meetings on the outside when he's able to.
Your Honor, I am opposed to a regular VR bond. The release to treatment makes sense to the people, but the issue here is that the victim in this case is the defendant's mother. She's called in the courtroom. She is leaderly, and I'm concerned about her way in which the assault battery, the battery, where I know I started to the report. So that's a great concern to me. Also, I don't know where the defendant was staying. That was his home, and he's not welcome back. So there's a concern of where he'll be. I would love to see treatment happen before the sentencing date, but a regular PR release bond would be great concern for her safety, as well as the defendant's stability and ability to have a place to live while he's out.
I'm going to leave that to Judge Washington. If after the point at which he's interviewed or assessed and Judge Washington feels he can be released, then that's fine. I think she'd have the same question for where he's going to stay and the like. But at this time, I'm going to deny the request for a change in bond movement. Thank you.
Thank you, Your Honor.
Court calls case People versus Winona Harvey.
As a defendant should not be carried active. Your Honor, on behalf of Ms. Winona Harvey.
Harvey, can you state your name, please?
Harvey Winona. Harvey.
Okay.
Your Honor, this matter is set for competency evaluation review. They, unfortunately, we have not received the report back from Forensic Center. I did reach out to them and they confirmed that we did the evaluation on the 20th. And they just told us that we should be expecting the report.
Okay. They completed the evaluation portion. They just need to.
That is correct.
What's going on, Judge?
Pardon?
What's going on in my case?
What's going on?
Yeah.
Waiting for some paperwork from some people regarding you. Once I get that, we can move your case along, okay?
Okay.
Okay. So what I'm going to do is I'm going to adjourn this out. Let's go the 18th. If we get it earlier, we'll move it up. September 18th, 2025, 9 a.m. I'm sorry?
I mean, we're not coming for today. Do we come and participate in something, or that's coming for no reason?
No, you're here for a reason.
I don't want to go back to my. I don't want to go back to my cell and have to come back down here again. So, but this it's my fifth time in court with you, and you won't say nothing.
I know.
Nothing.
Well, that's because we're waiting on other people to do some work. Because I can't make a decision or do anything until I get that.
Okay, sir. So what would you like me to do?
So I'm hoping the next time we have all of what I need. Okay?
Yeah.
All right. Thank you. Bond will continue.
Thank you, Judge.
Okay.
All right. You take care.
Sir. What's bond? All right.
Your bond, it's gonna stay where it is right now.
Okay.
All right. Court calls case People versus Devin Julia Martinez. Easily around. Yep. Just can't. Oh.
Stephanie Cannon on behalf of Ms. Martinez. Ms. Martinez, could you please state your name for the record?
Devin Julia.
Your Honor, at this time, we are going to waive our right to a preliminary exam.
All right. Is that correct?
Yeah, it's also address bond, for sure.
I will ask to address bond when appropriate.
Just make it sure.
You're waiving your right to a preliminary examination, Ms. Martinez?
Yes, sir. Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and if you committed them.
Correct.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Agreed.
Do you understand that?
Yes, I agree. I understand. I agree.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Thank you, Your Honor. At this time, we will waive formal reading of the information and we will stand mute as to charges.
Defendant name and waive formal reading, standing mute as to both counts. Court will enter not guilty plea. Pretrial will be set for September 8th, 2025, 1:30. Judge Hamud.
And Your Honor, as to bond.
As to bond.
Thank you. My client, when I met with her, I think Tuesday, she wanted me to let you know a series of things. One is she does have stable housing. If possible, she does want to be released to treatment at Spera for mental health and substance abuse.
Spera.
Yes, to Spera. She wanted me to ask in this case if we could get a 10% contingency on her bond, maybe 10,000, 10%. She wanted me to let you know that at the time she was on Ativan, she was in the middle of a psychosis. But for that, this would not have happened. She wanted me to let you know she's working for the government. She has a
I'm
stable
sorry,
job.
I just want to really fast interject. It was the hospital that put me on Ativan as well. So, for record, thank you so much. Sorry.
Nope, it's not a problem. And she wanted me to let you know that she has a cat. She lives with her fiance who needs her help with rent. Her wedding had to be postponed because of all of this. She has family support, her grandmother, dad, brother, mother, godmother, and friends. Your Honor, my client is just asking for the ability to be released. She understands that there will probably be a monetary amount associated with it, but she was hoping for 10,000, 10%.
What I'm going to do, I don't need a response. I'm familiar with this defendant. I'm going to deny your request I will sign a release to inpatient treatment on a personal cognizance. I'll sign an order to that effect. This time I'm not going to release.
And thank you, Your Honor. And I'll talk to you about what that means, Ms. Martinez. Thank you, Your Honor.
So just for technical purposes, I'm denying your request. However, I will sign that order.
You can go back,
Thank you.
Mr. Thurston. Thank you. I appreciate you, Mr. Thurston.
All right. Take care.
Good day. I don't think so.
Court does call the case. People versus Gary Taylor. Court calls the case. People versus Melissa Konwinski.
So, Santa White on behalf of Melissa Konwinski.
Your name?
Melissa Konwinski.
All right. What are we doing on this case?
Your Honor, we're asking for an adjournment for negotiations and to review videos.
You've seen the bond violation report.
Yes, Your Honor, and we have discussed it and I'm ready to address it when the court is ready.
Yes, I'm ready to address it.
Ms. Konwinski stated that she did drink, but it was only that one day. This was a one-day slip-up. She didn't take the test within 15 minutes because she fell back asleep. She takes mental health medications at night, which has been reported to CMH, which made her fall asleep. She wasn't avoiding calls. One of the numbers that she gave was her boyfriend's number, and he said that he didn't receive any calls. The other number no longer works. She did believe they have her current number, but that phone only worked on Wi-Fi, but she recently got it switched to a phone with a SIM card, so it now works all the time. This Saturday, the 30th, she returns to work at Dunkin' Donuts. On the 11th of September, she will start a part-time inventory job. She also receives her Vivitrol on the 11th. On September 22nd, she has an appointment for mental health addiction recovery and an evaluation with IHA Trinity Health. She has been going to AA and has proof. Her letters of recommendations from
How long has she been going to AA?
She has the proof. How long have you been going?
I've been going over a year. The Sunshine Group. But since I've been out of rehab, this is what I have.
When did you get out of rehab?
I got out on the 15th
Of what?
August.
And she does acknowledge that
Started drinking by the 19th.
that was one day after. And since then, she has been testing negative. She has letters of recommendation from Bear River Health and one from her boss. She volunteered in Hanover, Michigan at Rust and Dust and has a letter from there also. She realized she slipped, and for the first time, she wants this court to know she caught herself and immediately got back on track. And normally when she slips, she goes on a bender. Ms. Konwinski is asking for more time to test instead of twice a day so that she is more accountable to herself and to the court. We ask this court to recognize that she had no violations after that date and to give her another chance, especially since she has appointments set up for her mental health and for her addiction. She is also here today knowing that she could be remanded. She would also like to address this court.
Good morning, Your Honor. I first off want to thank you for back in December of evicting me from my ex's house. I'm glad that you did. I did not want it because that was a safe spot to drink. And since being evicted, things have changed. It's come into a lot in my life. I don't have to be in that household with him. And for that, I thank you very much. During the eviction, I was scared because I was giving up my way of drinking. And to this day, if I would have still been there with that man, I would probably be dead. So I thank you for giving me the eviction. And I do acknowledge and admit my part in this addiction and what I did. I'm not saying it was right, but I want to be fully honest with my recovery completely with sobriety because I don't have any more to give.
Response from the people.
This is an OWI third with 2 priors, both in 2021. This was a hit and run crash where the defendant was then located driving a vehicle with heavy front end damage. She was so intoxicated they couldn't even do the field sobriety test. Eventually, her blood test showed she was a 0.280. I have no faith that she's safe in the community right now. I'm extremely concerned that even with this grandmother given the levels that we see in this overlay testing. And I also know from the court, I'm sure the court's already seen it, it's towards the end of her testing window. So that leads me to have suspicion about what wasn't earlier in the day. I am extremely concerned for public safety. Should she be released at all, I would ask that her bond be revoked and she be remanded. If the court is inclined to release her, I would absolutely request a scram Tether. I think it's so willing to her whole way.
And Your Honor, I think she would be okay with that if she did ask for more times to test so that she could be more accountable to herself and to this court.
I have to put out that I don't think time organized that's going to be an adequate solution here with somebody that's at a foot too late, crashes, runs from the scene, and absolute fires.
Let me clarify. I was saying that she would be okay with the scram tether.
He's currently in some type of program.
She starts her program on the 22nd.
IOP intensive outpatient.
IOP intensive outpatient.
When?
September 22nd. She starts testing.
Do I have that? Is it somewhere in writing?
I haven't on that.
She emailed it to me. I can send it to the court.
Well, you can send it to the court along with some order. There's got to be some structure. She's not going to be in an IOP. I can't take the chance that she's going to go on another one of these, hop into a vehicle, and this time take somebody out. I can't do that.
Well, Your Honor, she has been negative, and that was just the one day slip up.
Yeah, but that's all it's going to take.
I understand.
She's got this is her third.
I don't have a vehicle.
She is.
Don't have a car. And I'm going to church and I'm doing AA and I volunteered. And I know what it looks like, but I wish people could see why I drink. To see the abuse and to see everything I went through. Why the hell I was living it.
Ma'am, I get all of that. The problem is that what's going to happen outside of the alcohol, you could potentially end up killing yourself just from the alcohol. But then all it takes is one of these slip-ups and somebody else goes. Somebody who had nothing to do with any of that abuse, had nothing to do with anything. They're all of a sudden wrapped into your world and your tragedy that you've been sorry. I get it.
I understand that. But I haven't drove in over a year, 2 years. I'm willing to go with alcohol, Tether, and I'm fine with that, Your Honor.
And Your Honor, she now keeps in contact with me as a support system. She calls me weekly and we talk.
And I have like letters.
Got to put together something. I'll consider it next week in terms of programming or something like that she's involved in.
Okay.
But
I do have IOP set up. I do have it set up with Medicaid rides and everything. I've been really working hard since I've been out to get back on my feet.
Going to happen again. Defendant's bond is revoked during the probable cause conference, September 4th, 2025, 9 a.m.
Yeah.
Okay. September 4th, Your Honor?
Yes.
Thank you.
Court calls case People versus Floyd McCall. Paul, excuse me.
Good afternoon, Your Honor. Constable Bates on behalf of Mr. McFall, who is present to my right. Can you state your full name for the record, please?
Floyd McFall.
Your Honor, today is the date and time set for PCC. At this time, we're going to be requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
preliminary examination in person, September 9th, 2025, 9 a.m. That's before Judge Valvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from people.
Your Honor, we have about fall like I would note that it's not just one incident, it's 2 different days. And that the report case before was about August 9th, Tuesday, he admitted drinking, but then we have in August 24th day. So
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
so, Your Honor, part of the reason that we find it concerning, believe that alcohol related also this, and that as far as the felony assault charge, the lethal weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that this would fall conditions violated when he's confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He's here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No. Just at my church, I don't have proof for it though. And I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Well, it looks like he is working on that, Your Honor. He's signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked, defendants remanded. Court calls case of the people versus Megan Moses.
That's Scott's people.
Afternoon, Your Honor. Call symbol based on behalf of Ms. Megan Moses, who was present to my right. Can you state your full name for the record, Ms. Moses?
Megan Moses.
All right, go ahead. Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off some of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor. As to the violation, Your Honor, my client still has the tether on her Still has the tether on her leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike, and like with the pedal. So she kind of had to adjust it. She lives far away from community corrections. That's why she wasn't able to go in and
have
get
a broken phone too. I had my number to the tether guy in my phone, and I had no way to contact.
So the tether came off in a pedal.
No, it's still on. It just pulled it and it poked it. Like there's something poking through it.
Call community corrections at any point.
That's what I'm saying. I was able to. I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my phone.
Was the tether going off?
Broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work.
So I didn't know where to call. What were you going to do with her phone?
I was going to call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone. Explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him and left the message out until tomorrow, I think, but I was waiting for someone to contact.
Did you go to the community corrections?
I called them. I did when I finally was able to figure out who to call when I got the email.
When did you call them?
I called.
How many days after this alarm went off?
Well, it happened on Friday, and then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is a tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she doesn't want to comply. Have you been to the community corrections at all?
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle or a phone at the moment. So I was requesting things through email as well, or trying to. I'm still charging it as well. Like I'm not trying not to.
She's not trying to. She's not trying to abscond, Your Honor. She's not trying to disobey the court orders. It was just. It seems it was just an accident, and just due to her lack of efficient communication methods, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So.
Yes, but I don't understand why she didn't.
She hasn't even secured a ride back yet today, so she's her transportation.
But why she didn't keep in contact more with community correction?
I think it's due to
her lack of. Went off almost 10 days ago.
Well, I was waiting. I'm sorry.
Go ahead.
I apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure, and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do as far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come and left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation.
I don't.
She still has the tether on. She's still been charging it. She's still.
What is?
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court.
Mm-hmm.
Is what I understood. And she is here today. So the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant in April of this year, the court gave her a chance. I had expressed concerns because she had 2 warrants out of Kent County, one for child support, one for an OWI third, if I recall correctly. And I was worried about seeing her again. The court gave her this tether as to track her location. So it is the people's opinion that strict compliance with the tether would be a condition of bond. So any tampering, anything like that. I noticed when the defendant was giving her recitation of what happened, she first said, I called my mom, and then very quickly said, I went to her work. Because she earlier had said that her phone wasn't working. So that is concerning to the people. That's something I picked up on. I think the court picked up on it too.
I did.
So I'm just worried about what's going to happen.
I don't think I'm being told the truth, in all honesty.
I understand.
Your Honor, I understand, but as I said, the purpose of the tether was for her to come back to court. I'm not sure why there's concerns if she's in court here today. And she's saying that she just misspoke because she's very nervous, Your Honor. She suffers from anxiety.
Probable cause conference will be adjourned to September 4th, 2025, 9 a.m. Defendant's bond is hereby ordered revoked. Defendant remanded.
Yeah, let's call it.
Court calls case People versus Justin Straight.
Hey, good afternoon, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Straight. Your Honor, may we approach on this matter?
Approach.
Thank you, Your Honor.
Record should reflect your bed bench conference in this case. I will grant your adjournment, but the bigger problem is regarding the defendant's bond. We release him from our jail, and in very short order, he decides to allegedly be in possession of a firearm and weapons. And at no point, because of previous conviction, he's a prohibited person and couldn't do that in any event. I understand he's maintaining his innocence in Middleton County, but those allegations are a violation of the bond in this case. Anything further?
Just for the record and for Mr. Straight's benefit, I did go over at the bench conference all of the 5 reasons we discussed as to request that your bond continue in this case, as well as, your adamant assertion of innocence in your pending case, you're in treatment, you're testing on you're supervised by 3 different methods, your treatment program, Livingston and Washtenaw. You sign up for another treatment program, you have a job interview tomorrow. And I verified with your Livingston attorney that you have no bond violations there. I did go over all of that with the court and the prosecuting attorney at the bench. So I have nothing further beyond that. And I, of course, showed the judge the documentation you brought.
Sure. I'll adjourn this probable cause conference to September 4th, 2025 at 9 a.m. As I also indicated, the release to treatment order, I would sign that order when that's presented to the court. But at this point, given what I see in this case, defendant's bond is revoked, defendant's remanded to jail. Court does call the case People versus Randall Jolly.
For the people here.
Judge Mark Ellis representing Randall Jolly. Sir, please tell the judge your name.
Randall Jolly.
Your Honor, this is a PCC. We're requesting an adjournment of that, but as the court is reviewing, we have a bond violation.
Yes.
May I address the bond violation, Your
Yeah,
Honor?
please.
Your Honor, I was not the lawyer on the record at the time that the arraignment was happening, so I wasn't there, didn't know about it. I did review it this morning. The bond document in the file does not order my client to be subjected to testing. It tells him don't do drugs. Now, I don't plan to use that.
Well, but counsel, go ahead. You can.
I don't plan to use that as my
want, but go ahead.
Not a problem. Judge, the problem is really the past and going forward. He tested positive for a drug which is a opioid inhibitor. That, of course, is a drug you cannot get and you cannot take if you are taking opioids because the combination of the two is likely to kill you. He has a prescription for that. So the funny sounding buprenorphine. Yes, he has a prescription for that. He today can pull out of his pocket a copy of his pill bottle showing his prescription.
Oh, he told about grabbing out.
So, Judge, I have that available to the court.
He's on Suboxone.
He is.
Okay.
Yes, Judge.
And that's it. But you're saying he didn't know that he had the test?
No. That is not my argument. But Judge, going forward, I believe there's a problem. He has missed the last two tests. The only reason he missed the last two tests is he is employed full-time at Ford Motor Company. He has his employee badge in his pocket. If you can pull that out, we will offer that to the court. He works a crazy schedule. He builds cars and he starts at 6 a.m. and he gets out at 5 o'clock at night. His testing facility closes at 4 o'clock at night. He's been there 5 years, but he doesn't have the sort of seniority to grant flexibility. So we apologize for missing it. So this morning, when I had no idea that there would be a bond,
what was the other drug? The amphetamine.
That was the initial time, Judge, and he's absolutely guilty of that. That was the first time he was ordered to test. Yes. Since then, he has not taken any of that stuff, and he will test negative today.
Well, there are two things. One, he had THC in his system.
Yes.
Whether he took it or not, he doesn't get a card till the next issued the next day.
Yes.
He also has abnormal creatinine, which is a problem because that usually will appear in rare circumstances, but typically when somebody's trying to mask.
So Judge, if I may, he absolutely flunked your first test, no question about it. But that was the first test, and since then he has been clean. He missed the two tests.
I don't know how you say that. He took one other test.
Yes.
And then didn't test.
Yes.
That's.
Your Honor, may I say something? I'm sorry to interrupt. I just wanted to say something on my behalf.
Go ahead.
I live in Wayland. I work in Wayne. It's a 2-hour drive. I drive literally 4 hours a day back and forth to go to work and get back home. I work till 5 o'clock. I called my probation officer. I want to test. It's not that I'm trying to get away from testing. It's impossible when it's at a time I can't get there. And I don't want to lose my job because that's some benefits for the kids. I mean, it's a rock and a hard place situation. And I'm just trying to figure out the best way to move forward without losing.
Did you talk to your attorney about testing closer to where you are?
No, Judge. I had no idea there was a problem. But I will say this. When I found out this morning there was a problem, I called testing facilities and I found places that have more relaxed hours. They also charge $130 to $150 for a test. At the moment, your court's charging them $12. And I mean,
I don't mind paying the money. It's the facility closed at 4. I just get off at 5. I have no issue testing, Your Honor. I really don't.
Well, when I look at this, you said if you're telling me you don't have an issue testing, I've got 2 missed tests.
Correct. I have an issue just because of the time, Your Honor. That's it. I'm hands down. It's just because of the time. And I'm not saying I'm not trying to skate. I want to, it's hard. It really is hard to get out of my job. It's an assembly line, so they can,
I understand how
I want to fix this. I do. I really do.
Well, and I don't know why somebody's not contacting the court or somebody prior to us getting to this point today. Then when you know you haven't tested.
Sorry, Judge. I read the email this morning. I had no idea there was a problem.
And it would be one thing if all that was showing up in the system is Suboxone, but that's not everything that's showing up in the system from the initial test. And then I really don't have much for August.
I'm sorry, I didn't.
I don't have testing for August. I mean,
yes,
effectively, I don't have it. The whole month. He doesn't test.
I want to, Your Honor. I do. I just need a facility that's a little later. I'm just scared to lose my job. It's really, I got my kids. I mean, it's just hard.
Judge, had I known, I would have made efforts to try to resolve this before today. I had no idea this was coming.
I just need a little help.
Any response from the people?
I'm trying to sort it out. My concern is not in the back of the date was July 2nd of 2024. So the defendant was arrested in possession of 56 pills of Adderall, which will show up in his system as amphetamine. And when he was arraigned just this past month, he's given the opportunity to test to show that he was clean, and it shows that a year later he had that amphetamine in his system. Granted, it was right after he was released from custody, but without the ongoing testing, there's really no way to ensure the safety of himself or the public traveling back and forth so much on our roadways. If he's not clean, I have the same concerns that the court does, but can't add anything additional.
Anything else?
Judge, I wish there was an easy answer.
Your Honor. No.
If the court allows, he will spend $150 and test at a private clinic.
Could have done that before.
Yes, absolutely.
That's my point.
You're
my
exactly
point
right.
is he could have done that before.
Yes.
There is nothing that prohibits him from doing that. What I have and what the prosecutors added is that the only test I have is that same drug that's showing up a year past is still showing up in his system. And then I don't have any testing. Simple as that.
You don't.
If it's all one, I really did. My probation officer, well, she'll tell you. Fine, yes, sorry.
Court test him today.
I can't get him in because of the time.
Well, he said by 4:30. Oh, sorry. Sorry, Your Honor, I'm sorry.
And find out if they can test him right now. If you come back dirty,
I won't.
I am putting you.
I have not taken none, I swear.
You know what? You need to be quiet about now. Can you see if they can get him tested?
Yeah.
He will test positive for the opioid blocker. Prescription, he takes it.
I understand that. Counselor, you probably should stop talking too.
I'm not good at that skill, Your Honor.
I know. You need to go over there and see if you can test. You don't get tested, you're gonna go.
So, Your Honor, may he take a sick day and test tomorrow morning first thing?
No.
Okay. Thank you, Judge.
I gave you your options. Go over there and test. If they let you in, fine. If not, you still got to come back here. And if you don't test, you're going.
Thank you, Judge.
Bye. He calls the case the people versus Randall Jolly.
Maybe for the people in your eyes.
Your Honor, Mark Ellis representing Randall Jolly. Jolly, tell the judge your name.
Randall Jolly.
First thing that I'll do is I will adjourn the probable cause conference to the 18th, 2025, 9:00. His test came back. He's positive for the marijuana. He did get a medical marijuana card the day after he first tested positive for marijuana. I'm going to suggest that you probably start or cease using that. But I have negatives on everything else. So what I will do is I'll continue his bond at this point with the admonition that if you miss another test, I'm not hearing argument. You're going. Simple. And then the other portion of that is that I will allow defendant may test what county is that? If you live in
Allegan. Allegan.
I'm a Michigan resident.
I'm sorry.
He may test in Allegan County at an approved facility by the Community Corrections.
Apologize, Your Honor, I have the BCC date one more time.
Is the 18th.
Your Honor.
His test results, he must sign a release so that his test results are sent to Community Corrections.
Your Honor, if I may, first of all, thank you. I appreciate it. My condolences on this docket of yours today. Judge, in the interim, my client contacted his boss at work. It is possible that he can test at the Ford Motor Company. Evidently, they have those facilities in some way. If that can be arranged, is that good enough?
As long as Community Corrections will approve the testing and the manner of testing, I'm not so concerned. But those results must be released to Community Corrections so that they can be reported to the court. So he'll have to execute the necessary releases.
I'd be happy to do that. Do we have any idea who I would contact at Community Corrections?
I do not. So what I'd suggest is you call over there, indicate his name.
Yep, very good. Thank you, Your Honor. Have a good afternoon.
Thank you.
The title of this case is Gary and Mary McLean versus Colleen McPherson. And you're Gary McLean, and you're Mary McLean,
Yes.
and you're Colleen McPherson.
Yes.
Also present is Pam Kirkland from Adult Protective Services and Tori Laughlin from Commission on Aging. And Megan Bauer from Legal Aid. Also present is Douglas Kuhlman, is this Fabius Township?
Yes, yes, it is, Your Honor.
Zoning administrator. So there's more here than meets the eye. What the case is presented here as is a termination of tenancy. This is a property at 15271 Mooney Lake Road in Three Rivers. It's in Fabius Township. I'm familiar with this property. There were some small claims cases and other things out there. The McLeans have a small farm there. They want you to move, Miss McPherson. This is called a termination of tenancy action. You are a defendant in a landlord-tenant case regarding termination of your tenancy. And as such, you have certain rights as a defendant in a landlord-tenant case. First of all, you have the right to hire an attorney. If you cannot afford an attorney, one may be available from Legal Aid. And one of the faces on the screen is Megan Bauer from Legal Aid of Kalamazoo. So she's monitoring what's going on here. And if need be, I can put you in a place where you can talk privately with her. We've also got the zoning administrator from the township, and we've got Adult Protective Services and Commission on Aging. You have a right to have the case heard here in St. Joseph County, where the property is located. I don't know why I have to tell everybody that because it's never been an issue even once, but I am required to advise people of that. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at this first appearance or file the demand in writing within 5 days using the appropriate court form and be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. If both parties are interested in mediation, the court can help set that up and make a referral to the Citizens Mediation Authority. You may be able to reach an agreement with the landlord that means the case would get dismissed. The court must provide you with that information to prepare a conditional order of dismissal, or perhaps one of the attorneys would prepare it if there is one. All right, Ms. McLean, at this point, you're all living in the same house at Mooney Lake Road. Is that correct?
Not correct.
All right. Is this the apartment in the barn?
Yes. And when we got our permits in 92 from Mr. Niken, we permitted a farm dwelling inside the barn because we intended on doing livestock and needing agricultural help. So that was built in 93. And I have the original building permits with me.
All right. Is there a lease?
No.
Does she pay rent?
She did a little bit. Mr. Kuhlman pointed out to me that my kindness gets me in trouble every time because he's known me a little bit.
It's called no good deed goes unpunished.
His exact words.
I think he heard that from me.
Yeah.
All right. So at this point, how long has she been there?
In January, she appeared with not a dollar to her name and her belongings in a snowstorm, and I allowed her to move in with nothing.
Is she related to you?
No.
How do you know her?
I've known her through Facebook for 2 or 3 years. She'd come out a couple of times and visited, and when I had different things open, and then we visited just prior to that because my goat birthing season was coming on, and my Mr. McLean loves to be able to go away for a little while in the winter, and some of my farm help is to help with whatever's going on. And she'd be so wonderful help. She'd help me with the birthing of the goats and this and that and the other, and seemed like a very nice woman. She only had one pet and.
All right. Well, we don't need to get into this issue right now, but let me ask Mr. Kuhlman, is this place lawful for habitation?
No, Your Honor, it isn't. And that's the whole problem. Back in May 30th of 2017, an administrative search warrant was executed on this same building, actually the entire property. In May of 2017, this area was placarded as unsafe for human habitation. No enforcement action was taken at that time because Ms. McLean was cooperating. I would just indicate for the courts that I do have 2 open cases coming up on September 23rd. Where on this occasion I did cite Mrs. McLean for 2 violations of township ordinances.
All right, well, let's talk about that. Ms. McPherson, they want you to move. You don't have a lease. You're not paying any rent. And the township says you're not supposed to be living in there. Have you made any provisions to try to move?
I've been trying to move out of there since February. I paid rent up until June 15th.
How much was the rent?
$1,000 a month. And I have.
Stop. So you paid $1,000 for January, February, March, April, May, and June?
Yes.
And you disagree with that?
Absolutely did not pay that.
All right. Well,
I did set the rent at $1,000 in February when I could see she would be of no use to the farm and high so that possibly she might find a place to live. And she was amicable in the beginning.
all right. Well, obviously, at some point, you're going to have to move out of there. So let's hear from Miss Kirkland of Adult PS. Is Adult PS attempting to help her find a place to live?
We are, Your Honor. And that's why Tony Laughlin, she's with Area on Aging, victim advocate. She is assisting me in helping Colleen find a place. Colleen has been looking locally and as far as Kalamazoo as well.
Ms. Laughlin, have you had any success with that?
We do have potentially an apartment, but it is.
All right. The law requires that I continue this matter for at least 7 days, which would take us to next Friday. Meg, this doesn't appear to be much of a legal defense. She's not supposed to be living there. They need to get her out of there. We're not asking for money damages at this time. And she's got 2 resources trying to help her find a place to move to. So, yes.
I know your position on this, but is it possible the notice is deficient?
Well, let's find out. First of all, let me look at our docket here. Next Friday would be September 5th. What's deficient with the notice?
I am not sure. I haven't seen it, but I do have some notes in front of me regarding this case.
Well, the notice to quit was filed July 16th. No, the complaint was filed July 16th. The eviction notice was something they got off the internet, which looks pretty good. That was served July 14th. So that may be the problem. The notice to quit was served 2 days before the complaint was filed. No, served on May 10th, what she says. So it was filed at the same time, but it was served on May 10th. That's what my note says. So it appears to be adequate notice.
Thank you, Judge.
At any rate, we're not arguing now about money. This is about possession. If you move and the McLeans sue you for rent, we could have another hearing. That's problematic. A, you've been placarded, so you're not supposed to be renting it. And B, you don't have a lease. So you may just pursue getting the property back and not worry about money damages. But let's see what we got for time for next Friday.
Your Honor,
Now, yes.
I did inform Colleen from the very first day that I couldn't just rent to anybody for any reason because of the zoning thing. So she immediately went right to Gilguman. I gave her the ammunition. But our apartment is in horrid shape right now. I have a video, if we could play it. And my husband's cousin, Sandy McLean Hummel, is here because she was there.
Well, we aren't there yet. We're just about possession.
Oh,
so if you get her out and you want to sue her for money damages, you have to file a separate action, probably in small claims court.
But every day that she's there, wow.
Go ahead.
It turns into a mess. She smokes incessantly. It has got maggots hatching out and flies that's filled.
Yes, no good deed goes unpunished. So you put her in there, you don't have a lease, she's a tenant at sufferance. I can't just throw her and her baggage out on the street. We have to go through this process. You've been at it since May, and that's really a long time, longer than it should take. You have to give her 30 days notice. Then you filed the hearing in July. I'm sorry, it took all the way from July 16th till now, but I was gone for 2 weeks in July and then was gone for a week in August at the judicial conference. So here we are in late August. But I have to continue this at least 7 days, and she gets 10 days from that date to move out. So next Friday is September 5th. September 5th is afternoon day, and I would set this for 2 p.m. on 9/5/25 for a second hearing. Now, if you move by September 5th, that's not likely. But if you do move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. There is no lease. There's no security deposit. But you're going to need to get out of there. Now, they've got some concerns about smoking. Is there a smoke detector in there?
We took them all down.
No, I didn't.
All right,
They're
well,
gone.
I don't, so I got some concerns about fire hazard in a barn, but also she says there's cleanliness issues. You're ready to move. You would like to move, but you haven't got anywhere to move to. And so you've got two agencies working on moving you.
Yes.
And hopefully they can find something. Otherwise, we're going to have this hearing. We're going to address this next Friday by Zoom once again. You're all welcome to come here live. But we'll deal with it next Friday at 2:00. The law requires that I set a second hearing. Didn't used to, but it does now. Then you get 10 days from that date to move, or you'd be subject to being evicted, which essentially gives you until September 15th to move. Or on the 16th, the sheriff could come out and put you and your stuff all out in the street. So that gives you 7 plus 10, 17 days from today. From either of the agencies, do you have any knowledge whether she was paying $1,000 a month rent?
I have no idea, Your Honor. It's just kind of been back and forth. He said, she said.
Ms.
No idea.
Laughlin?
So Ms. McPherson did provide me with the text communications between herself and Mary since January. An extensive amount of communications where it was indicated and confirmed by Mary in text that she had been paying $1,000. They had an agreement about what the $1,000 would cover. There are some issues that about the notice to quit, kind of all of it. I mean, there's a lot. So
And you're not being picked up very well. What's your concern with the notice to quit?
So the paperwork that Colleen had received, it was back to back, that 30-day notice that said that was sent on May
10th.
served. On the back of that was a 5-day notice that they served on July 14th. That was the most recent notice. And then 2 days later, they filed the paperwork here.
Yeah, I think the notice is sufficient. If she served one on May 10th, and then she served another one on July 14th, the May 10th one would supersede, and she's got more than enough notice before the complaint was filed. At any rate, she needs to get out. She's not supposed to be living there. They're not supposed to rent it. There are some health and safety issues. There may be some money about whether rent was paid or not. But we're not about money at this hearing. We're about possession. And so once she vacates, if you want to sue her for money, you're going to have to file a small claims case. But since it wasn't supposed to be rented in the first place, that may not go very far. So what you just may need to pursue is possession. All right, everybody on board. We're going to deal with this next Friday at 2 p.m. All right, we'll address it at that time. And you're welcome to come back live again or appear by Zoom. I'm going to do my usual segue into general civil matters, which is always a problem. But let's see what we got here. Grant v. Ballard is set for 10:50. But everybody's here. It's 9:50. I guess that's the next one we've got. Kyle Grant versus Danielle Ballard and Danielle Ballard. All right. Mr. Grant, can you hear me?
Yeah, I'm sure you can.
Miss Ballard, can you hear me?
Yes, I can.
This is another one of those evictions where the parties are in the same house. A Pulver Road address. Mr. Grant has served a notice to quit on the defendant some time ago and once missed.
Let's see.
Whoa. Sorry about that. Miss Ballard, Mr. Grant wants you to move. What's your position there?
I have no place to go. Yeah, I've been looking since he gave me the 10-day to quit for ever it seemed like for a place to stay.
Yeah, the notice to quit was served on July 3rd.
Yeah, when he tried to give that to me,
I lost her. There she's back.
yeah,
All right, he wants you to move. You haven't got anywhere to go. Was there ever any rent? Oh,
no, we had a verbal agreement for exchange and work to organize and clean up his yard, in which I was doing until they started sabotaging
Well,
me.
the verbal agreement is not
Generator
worth.
and shut the power off. And
All right. Well, are you all living in the same house?
he lived inside the house. I live above the garage.
He shut the power off?
Yeah, the lady in the house decided that she didn't want me there, and she cut the power wire to my room from the breaker box. She then steals my generator that I was using for power, shuts the water off to the water spigot outside, locks me out of the house so I can't use the bathroom. And I mean, this is ongoing. I've even made police reports about this stuff. And
All right, well, let me stop you.
then I get two.
Stop.
Oh, sorry.
Stop. All right. He can't do that. But you can't live here. He wants you to move. You don't have a lease. You haven't moved because you got nowhere to go. So you're in a deplorable circumstance. You're not paying any rent. You're living above his garage. And somehow that is our lot in life. You need to get out of there. Mr. Grant, you can't shut off her utilities. You can't turn off her power. You can't turn off her water. And you can be subject to the lockout law and you can end up paying her money. Miss Ballard, are the utilities working now?
Yes.
Have you made any effort to find a place to go to?
Yes.
Any luck?
I'm sorry, my phone cut out. I've been trying to find a place since, like I said, since he asked me to move out. I just haven't had any luck. Nobody has a room there.
Well, right now your rent is zero, so you're not going to meet that, but you can't stay there. This probably isn't even a lawful dwelling. We had another case at Fabius Township. This is Fabius Township where someone's renting an apartment above a garage that they really can't do. Mr. Grant, how did she come to be in there?
She was basically in the same situation when she had nowhere to go. And I wasn't nice enough to let her, at least I told her she could stay there until she can find a further place to live. And then, of course, she did yard work and stuff like that. And she did fine with all that stuff. But like I say, there was just an incident that happened with it because she wanted more than just the one room that I had upstairs. And I built it for storage in it. And so anyways, she cleaned everything out of there and took it downstairs. And some of the stuff wasn't mine. And of course, my other, the person that I got living with me, it was her stuff. And so I got yelled at for that. And I'm getting it from all directions. And I'm done with it.
Well, Miss Ballard, as a practical matter, you probably can't even live here. If the township was clued into this, they would probably condemn it. So, but your friend can't cut her power. I don't want you running this on a generator. That's a
Right, yeah, that's not happening. Like I say, you know,
All right, well, I have to-
all right, I turned it right back on. Everything is, you know, the water, same thing, you know, so that's not an issue.
I'm going to continue this to September 5th. That's next Friday at 2:35. Now, we're going to revisit this next Friday at 2:35. If he gets what he asked for, which I'm inclined to give him, you would have 10 days from that day to move out, which would be the 15th of September. But you can't continue to stay here. There's no lease, there's no rent being paid, and it's probably not a lawful apartment to be rented. So I hear it all the time. I'd move if I had somewhere to move to. Right now, your rent is zero, and you're not going to find any place where your rent is zero. But it just is what it is, and you know it. You'd move if you had a place to go to. You don't like it there either. But this forces the issue. People would never move. I know when they moved to. 9 years later, I haven't found any place to move to. That's what this proceeding is about. It forces the issue and compels the people to move. And if they don't, then the sheriff moves it for them. So Miss Ballard and Mr. Grant, we're going to address this again next Friday at 2:35. Miss Ballard, do you have any questions?
No, sir.
Okay. Now, if you do move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. There is no lease. There's no security deposit, but that's what the law requires. All right. Hopefully you can find a place to go, Miss Ballard, because we can't continue on like this. All right. I'll see you both next Friday,
At 2:30, you said?
2:35.
2:35.
But 2:30 is fine. All right.
Okay, thank you.
And I've got a couple of arraignment cases to do on Mr. Joshua Joseph Brown. Is that you, sir?
Yes, sir.
All right. This gentleman on the screen with us is Mr. Keith Stickley. He's the chief public defender for St. Joseph County. I've got two cases I need to see you on. The first one is 241755SM. In that case, you're charged with 2 counts of assault and battery. And your lawyer is Luke Knopfsinger. You were set for a pretrial conference with your lawyer and you didn't show up. So I issued a bench warrant for your arrest. And I came into work this morning and saw that you'd been arrested. So let's talk about that first case.
Good.
There it is. Well, I don't have both cases. But Peter gave me the felony case, but not the misdemeanor case. So let me find the misdemeanor case. We're going to get this case back on track. 241755. All right, in that case, Mr. Brown, you were charged with 2 counts of assault and battery on Philip Warple, which occurred allegedly on September 16th of 2024. It's in there on the system incorrectly. We have to fix that. That room is so noisy. Anyway, I appointed a lawyer for you, Mr. Luke Knopfsinger. The prosecutor had offered a plea to there's 1 count of assault and battery. Well, we had a trial, you didn't show up. So, I set the bond at $500 cash or surety with a 48-hour hold. I'm going to reset the attorney pretrial for September 5th, which is next Friday. It's not a lot of notice, but you're in custody at 8:30. I think Mr. Nossinger's set to be there that day. How did you come to get arrested last night?
I was in at the house and Steve Cop came over and said that I had a warrant.
Are you still at Congress Street?
I'm over here at Youngman Road and Golden Pond Trailer Park.
What lot number?
23.
Who are you living with?
Jerry, hold on a second, I just woke up. There's a couple of my friends. There's Tara Lynn's. But she get a boyfriend stays there too.
All right. Well, so they came to that house and arrested you?
Yeah. I don't think they was actually looking for me at first or arrested me.
They came out there, ran your name, and arrested him?
They arrested me, yeah. Over like a bike or something. Wanted me to pick up a bike or I don't know what it was about. But they ran my name and put me in jail.
Are you working someplace?
No, it's supposed to be starting, yeah. It's supposed to be starting there in Mallball. But they don't have, it's hard getting in there because they don't have no receptionist. So I get called in and then there ain't nobody there to talk to.
All right, well, I'm going to reset this for next Friday at 8:30. Bond is $500 cash or surety. You failed to appear before. We set a $2,000 bond, then I gave you a PR bond, then you failed to appear in November of 24, and then in December of 24. Also, you got several unpaid fines, and you owe me money in some cases, and you got a new charge, which we're going to talk about in a minute. You've got an unpaid fine in a trespass case, 232223.
We laugh because we care.
You got an unpaid fine of a retail fraud and filed 24910. You got an unpaid fine in an assault case. This is a bad one. Aggravated assault. It was part of a payment plan that I put you on last October. You charged with aggravated assault. I gave you 16 days jail credit, 16 days, and a payment plan. You came up and set up a payment plan, and I don't believe you ever made a payment. So you have a payment plan on 3 cases with no payment. Those cases are 24910 for 1448 SM. And 24232223. Yeah. I'm not sure what the total is. $800. Anyway, you never made it a payment. So I'm gonna set this one for a pretrial conference next Friday with your lawyer, Luke Knopfsinger. Did you ever talk to him?
Just that one time.
But then you didn't show up in court either in November or December, so I issued this warrant. So I'm not sure if you fell off the grid or what. Now, to further complicate things, you got a new case. Let's talk about that one. That one is in my queue. The magistrate would normally do this, but I'm here and I'll just do it. In that case, you're charged in a formal complaint that alleges retail fraud in the first degree, that on or about April 22nd, you were at the Meyer store in Sturgis and you stole property worth more than $1,000. And they conspired with Christina Drake to steal that. So they charge you with retail fraud in the first degree and conspiracy to commit retail fraud. Those are felonies punishable by up to 5 years imprisonment and a fine of up to $10,000. You're also charged as a fourth habitual offender, making the maximum punishment for that up to life in prison. Now they're going to send you to life in prison for retail fraud, but because it is a habitual, the maximum is up to life. File number is 25765FY. I need to get that case also on track. In this affidavit, they indicate that you left there with $1,081 worth of stuff. You had $1,081.21 worth of stuff in your cart. She had $972 worth of stuff. So the combined value was over $2,000 plus the value of the carts. They found actually her purse. At any rate, there's video of this that they have from the store. So you fled. They didn't make an arrest at that point, and the prosecutor issued a warrant. And that was in April. And that warrant has been outstanding since April. I'm going to show a plea of not guilty. I'm going to appoint an attorney. I believe it will be Jordan Harden. I'm going to set a pre-exam conference for 9/9 of 25 at 8:30. And a preliminary examination if needed for 9/16/25 at 1 o'clock. Now, let's talk about this. You've been AWOL on my other case since December. While you're on bond and under a warrant, you were in the Meyer store allegedly in April on the 22nd. Now, they never caught up with you, so they never served the other warrant, ran away. Then you moved from Sturgis to rural Constantine or Three Rivers, and that's where you've been. They just happened to arrest you by happenstance. Now, you did have a Quaker Street address. Is that one? What was that one?
That was just a prior address that I lived at.
All right.
Sometimes
Did you?
I've been not trying to move around a lot, but when I was able to move back over to Golden Ponds over there, Youngman's, my children live out there, and the person I live with, they have a car, and they told me that if I get a job, they can get me back and forth to work. So that's been working out really good. So it's kind of getting my life back together and getting everything back on track. And actually, I'm glad that this officer came and finally caught up with me, that maybe I can get all this stuff behind me now, because like I said, I think that probably they're trying to get a hold of me.
All right, hold on. All right, I'm going to set a bond in that felony case. It's a fourth habitual offender. You were alleged to have a co-defendant, Christina Drake, and I'm not sure what happened to her. I didn't look her up. You've been AWOL on a assault case since November and December of last year. You never bothered to call your lawyer or make any arrangement to come in. While you're on that status, you got charged with this case as a fourth habitual offender. They only arrested you by happenstance. I'm going to set the bond in the amount of $2,500 cash or surety. The conditions are barred from Myers. I guess that's it. No weapons, no assaultive behavior, because you do have an assault and battery case and you have unpaid fines and costs and an aggravated assault. You were drunk, according to this, when they arrested you last night. And you're kind of sleeping it off here today. All right, you got a $500 cash or surety bond in the misdemeanor case, which I set back in December. The new case, I appointed a lawyer, Jordan Harden, and set a pre-exam conference for the 9th of September at 8:30 in the morning. Your bond in that case is $2,500 cash or surety, no weapons, no assaultive behavior. On my order, no alcohol as well. Are you likely to make that bond?
Probably not, sir.
All right. Well, as you said, the good news is at least we're going to address these issues. You've also got hundreds of dollars worth of unpaid fines and costs. So you've just been kind of staying under the radar. But $2,000 worth of theft from Myers is greater than the norm. I don't know what kind of stuff they allege you took. There's allegedly a videotape of it, and your lawyer can get a copy of that and view it with you. If you make bond, I want you to call your lawyer and make an appointment to discuss this with him. If you don't make your bond, she'll come out to the jail and see you. All right, sir, you're good to go.
Thank you.
All right. Good luck, sir. I'll see you on the 5th. Thank you, Mr. Stickley.
Sure, that was not much, but you have a good weekend.
Yeah, I was unwilling to give him a PR bond in light of all the circumstances. And he'll sit. Maybe we can get these both taken care of. All right. Thanks for your help. I'll see you later.
Oh my. You know what that sound means, right? That's right, ladies and gentlemen. We've come to the end of the show. I have nothing else to give you right now. It's already over. It's already been almost 2.5 hours. 2.5 hours. So, thank you all very much for showing up. I do appreciate you all. Thank you very much for hanging out with me today. I have a few thank yous specifically to give out to my friends Zach in Florida. Thank you very much for your $5 contribution to the channel. Rhonda, thank you very much for your $20 contribution. And Darth J, thank you for your $5 contribution. All of you are greatly appreciated. You help the channel out so much. So much so. Ladies and gentlemen, I'm your lone Wafusel. I'm not on camera, but I am here, and I am live, and I am real. Hope you enjoy these little fun, obvious AI images that are made in jest and meant to be funny. I'm going to put them full screen so we can all look at them together. It's been a great show, ladies and gentlemen. I do appreciate you. What the heck am I doing? There we go. There we go. That's the right one. They're real to me too, Katie. They are real to me. Look at him loving life in that convertible. Look at her driving that little red Corvette. Oh my Lord. And thinking of Regier in his little purple bonnet. Wow. The things AI can give to us. Right? I mean, I completely agree with this comment right here. Kids, I'm your lone wolf Oozle. I bring you these crazy court hearings every day of the week. Keep an eye out. There'll be more to come. We're live every Saturday, same time. We're live every single night of the week around 8 p.m. 8 p.m. Central Time, 9 p.m. Eastern Time. Love you guys. Talk to you later. Will there be court money? Probably not. Probably not. Considering Monday is Labor Day. But the real question is, will there be court to watch here? Channel Monday. That's a completely different question. That's a completely different question. See you Monday.